performance. Right? I am remindful of the days when I joined the judiciary in the year 2001. And I had no, though we were taught the specific relief act in our curriculum at the university level, but we had no idea how to put it into practice. Whenever I would go through the brief of the seniors, I would find myself very confused as to how a relief is to be sought, how it's to be done, which law governs it, and all that. So ultimately, I gained consciousness, in fact, insofar as that drafting or the pleading part of it is concerned. And day by day, it grew out of bounds, and finally, I got it. Insofar as this act is concerned, it's very vital, given the pleading and the drafting of a suit exclusively, I say it. I'm also remindful of its genesis when I found that earlier there was no concept of the specific relief. There was no concept as such, but it got introduced later. Earlier, the people would ask for the damages only, and a time came when the relief of like performance of the contract came into practice. This specific relief act, in fact, so far as its classification is concerned, it's classified into many chapters, and exclusively it's aimed at one, the recovery of the possession. That would mean the recovery of the movable or the immovable properties. Second is that the contracts, whether it is the breach of the contract or whether it's the performance of the contract. And prominently, it talks about the reliefs which we normally ask or crave in a suit. That's whether it's in terms of the declaration or injunctions. Now, the specific performance act, the chapters, I will number them. One is the recovery of the possessions, specific performance of the contract. We have rectification of the instruments also. We have rescission of the contracts, cancellation of the instruments, then decrees, declaratory decrees, injunctions, perpetual injunctions, mandatory injunctions. So all these sum up in this act. Now, its utility and its vital import is mainly aimed at the contracts and the recovery of the possessions. For example, when we draft a suit for recovery of the possession of the property, normally we come across in the courts that the recovery of the immovable properties, exclusively land and all that. What do we do? That we seek its recovery. We seek its recovery, and that recovery is to be sought properly under law. We file a suit. We file a suit in this regard, recovery, and when we do it, we normally do it in terms of what we call as the proper section for recovery of the property. And this recovery of the property, when we file it, there's a specific mechanism entailed in section, what we call as section 6. And that section 6, in fact, gives us the mechanism to recover it, but there are ingredients that we need to follow. In the recovery of the immovable property, simultaneous applications of the laws also, including a law of limitation, that also comes into effect. And when we find that a property needs to be recovered within a timeline, within the lease timeline that we have to do within a period of 2 months only, within a period of that, when the breach is, when the property is, when one is dispossessed of the immovable property. So the recovery of the properties, movable or immovable, comes under this act. It also gives us a sense how to draft a plaint and also depends upon the input of the client as to what as to what the facts of a particular case are. For example, if if somebody is dispossessed of the immovable property, our endeavor in the first instance should be in a practical way to get it recovered within the limited period of time. Recovery of the property, recovery of the possession, recovery of the possession, six, if he is dispossessed, and then if the property, if somebody is in possession unlawfully or illegally, then again there is a mechanism which is to be followed for its recovery. So that we do under the specific relief act. Specific relief act. And coming to the now contracts. Contract, in fact, is the all. It's the principle of law that all contracts are not enforceable in a law. Means you cannot enforce all the contracts, but there is further classification that some part of the contract is enforceable, some parts of the contract, and some contracts are not enforceable. This is how the Specific Relief Act guides us. Insofar as the contracts which are enforceable in law, there is the what we call as the mechanism entailed in Section 10 that as to how the contracts can be enforced, which nature of the contracts can be enforced in law. Like we have that when there exists, when there's a scope for granting of compensation, then courts cannot, or courts normally do not come to the rescue of performance of the contract, or when the act agreed to be done is such that compensation in money is an adequate relief, then courts grant the relief likewise. Similarly, court cannot be expected to observe or see the continuity of a damage. In that situation also courts, they do not come into the Specific Relief Act. Is in fact the from pleadings point of view, it's very important. It's very vital. One has to keep it in mind while drafting a plaint and while keeping in view the facts or the inputs of a client as to what he is asking or craving for. And it's specifically aimed at the contracts and recoveries of the possessions. Moreover, when we find normally a plaint with a relief, when we have to insert the reliefs in a plaint or ask for the reliefs, we have to be very wise, giving regard to the what we call as nature of the declaration that is to be sought as against the relief. These reliefs, in fact, are prominently expressed in the Specific Relief Act. And the relief, that is when we have to get our right declared, we have to be again very wise. When a relief is to be what we call asked, which nature of relief, where a right is to be determined, how it is to be determined, and under what circumstances is to be asked for, and how a court can grant the relief. So all these things, in fact, are generally, they come under the Specific Relief Act. And insofar as it also, in fact, it also includes that where a party wants to cancel the instrument, cancellation of the instrument also is covered under it. We can also rescind a contract. A contract can be rescinded also. Or if we want the specific performance of any contract, we can also do it. We can also do it under this Specific Relief Act. Sometimes a party wants to rescind the contract, or a part of the contract is not to his liking or his will, then he can approach the court, file a what we call a suit for rescission of the contract or for cancellation of the instruments. Instruments, you understand, are of many types in the law. A sale deed is also an instrument. so is the gift deed and etc. So we can get it cancelled at the option of the plaintiff, or at the option of the party who approaches you. So in this regard, in fact, I have also I can also say that at the time of drafting a suit, one has to be what we call as the conscious of the vitalities of this act. That's the Specific Relief Act. So it plays a very vital role in drafting a suit and asking for a relief. Now, the recovery of the possession, movable and immovable, that I have said that we can recover the possession, that is movable, and the immovable property also. And in cases where the property is, where the contracts are to be specifically enforced. Now, when there exists no standard for ascertaining actual damage, then there is one set of criteria in law, and cases in which specific performance of a contract is connected, that is, the situations are governed otherwise. When we go by the specific performance of a contract, where a party is unable to perform the whole of his part of it, but the part which must be let unperformed by only a small proportion to the whole in value and admits of compensation in money, the contract may, at the suit of either party, directs the specific performance of so much of the contract as can be performed and award compensation in money for the deficiency. You might be coming across with the cases where the service contract is questioned where the service contract is questioned. We don't get injunctions normally in these cases, accepting the compensation or the damages, because the compensation or the damage is the adequate relief, and the performance of the contract in this case, in fact, is not possible given the law on the point that the contract cannot be specifically enforced. Similarly, we have many instances where we can get the contract performed by the court through its indulgence while passing injunctions of the like sort, and where we cannot. But there is also a situation when there is negative covenant in the agreement. After all, the hunchback is on the agreement of the parties. See, contract is basically an agreement between the parties, and when we find that there is some shortcoming in the contract, we can ask for its rescission. We can ask for the cancellation of the instrument also. There's also a provision in the act in itself. Or if you say that you want some obligations to be performed by the one who wishes to perform the contract part, you can do it also. But once the compensation or the damage is the adequate remedy that can be granted by the court. If there's a negative covenant in the agreement in itself, then court can certainly pass an injunction. Otherwise, courts restrain or refrain from passing injunctions in the matter. Court cannot pass an injunction in the cases. So that's also classified in what circumstances or situations court cannot pass the injunction. That's also provided in the act in itself. Then under what and when court can pass the injunctions. Injunctions are of varied nature. Perpetual injunction is there. There is that permanent injunction also. There is mandatory injunction also. So permanent injunction would be issued by the court after determination of the rights of the parties, that would operate permanently, or that would act permanently as against the party or in favor of the one who approaches the court. Similarly, the mandatory injunction, where the court can compel the other side to perform the part of the contract or refrain from doing a particular act, that also comes under that provision of law. Similarly, there is also a scope of for grant of temporary injunction. Though temporary, there's a separate chapter for grant of temporary injunction in the CPC under chapter 30, under order 39. There's a separate chapter for that. But temporary injunction can be granted by the court, and that temporary injunction has the nature to preserve the list till the rights of the parties are conclusively determined. And these injunctions are normally the nature of the temporary injunction uh, is to preserve the list till the rights of the parties are determined, and in the long run, when the perpetual injunction or the injunction one in the nature of the mandatory injunction or mandatory injunction is passed, that's all. So that's aimed at compelling the party when a right is finally decided in favor of one and against the another. And here we can say that this civil individual right, when there is a scope for enforcing the civil individual right, then we see it in the light of the Specific Relief Act. Now, this Specific Relief Act is in fact is all aimed at the provision of remedies for enforcing the contracts and for recovery of the possessions and asking for the reliefs in the matters which you may come across. Therefore, while drafting a plaint, it is of vital import, or it is to be kept in mind, that which type of relief is to be sought. And if that relief, say, the parties contest a matter over years together, and later at the fag end of the trial, they come to know that the suit was not maintainable for the want of particular provision of law. Therefore, one has to be very, very cautious while drafting a suit. And the first, what we call as the first glance in this regard has to be on the Specific Relief Act. It plays key to the drafting of a suit exclusively, I see. And it is that way very important when we agitate a right or when we want a right to be ascertained by the court. Similarly, when we are in the process of enforcing a contract, we have to see its nature. If its nature is such that a compensation can be granted or it's an adequate remedy, then we get it. So then we have to mold the relief that way. Otherwise, if there's a scope for enforcing a contract, which we find in the marriage agreements and all that, that's provided in the act in itself, I need not to say it. But at the end of the day, we find that the contracts, some contracts are enforceable in law, while as others are not enforceable. And those which are not enforceable, the compensation is the adequate remedy that courts can grant. The relief that is which we at the conclusion of the drafting of a suit ask has to be done in view of the recitals of the plaint. The recitals of the plaint must match the relief in all its entirety, keeping in view the effect of other laws as well. Like we see that the Limitation Act, in case of recovery of the movable possession, in case of recovery of the immovable properties and all that, there's a limitation. So sometimes the dispossession of the property has to be reported within a limitation period or within a timeline of 2 months only. Then and only then we can file a suit in terms of Section 6. Otherwise, there is legal embargo, which may come in the way while we want our this right to be determined by the court. Similarly, when one is the lawful owner of a property and he is not in possession of the property, the limitation which is provided is of 12 years. So we can pick upon this act and get the possession recovered. And on the contrary, if somebody is in possession, legally or illegally, or he is in lawful or unlawful possession, and he is dispossessed one or the other way, he can claim possession. He can claim possession, and the hunchback is again on this act. On the basis of this act, while banking upon this act, he can claim the possession. So that remedy is also provided in the specific relief act. When we file the suit for partition, possession of the property, we can also claim other reliefs. Like we can also claim the rendition of the accounts. We can also claim any other mesne profit which may arise out of that property. That's also incorporated in the specific performance act, or the specific relief act, we say. And in terms of the amendment in the year 2018, so it's also provided that if, at times we find that the declaration which we are seeking against a right, if in the follow-up there is the scope of there's the scope that a consequential relief may be granted by the court, and if we are not asking for it, the court may not come to our rescue later. So declaration of a right and a consequential relief which may be attached to it has to be asked or claimed once only. Otherwise, it would be a vanity in law. The court may not come to our rescue. I again say that there is negative clause. If there is any negative clause in the agreement, only negative clause in the agreement that can be enforced, and court can grant an injunction for the breach of it to avoid or to prevent the breach of it. Obligations are cast vice versa in the nature of a contract. If there are breaches, the nature of the breach is to be understood in the real context. If the nature of the breach is such that courts do see can be prevented, the courts can come to the rescue of the party who wants that obligation cast or who wants that breach to be prevented. That can be done. Sometimes the situation arises that courts do not, in fact, come to the rescue of the party that way or prevent the breach. Compensation or damage is the adequate remedy, which will be equivalent to the breach of contract, or that can be ascertained if it is determinable. So the damage, if it is determinable, so the damage has to be determinable. If it is to be molded in terms of the relief, that can be done by the court. So summarily, we can say that these remedies, the remedies for the breach of the contract, are all there. They are all practical in nature. Court can come to the rescue of the party who complains breach. And the classification, as I said, is already provided in the specific relief act, that when the courts can perform and when courts cannot enforce the part of this contract. Now, at the tail end of it, we can say that sometimes a party feels that a contract, in fact, the part of the contract is performed. Part of the contract is performed and the major part of it is yet to be performed. Then that aspect is also governed by this act. And the relief which can be molded or asked for at that time depends upon the circumstances of the case. Normally, we take this plea in these type of suits when we enforce the specific performance of a contract. We say we are willing to perform the part of the contract. We have to show the willingness to the performance of the contract. We have to show the willingness, and also the facts should suggest that the plaintiff, whosoever approaches the court, at all times ready to perform the part of his contract. And when part of the contract that is performed by a party is too sufficient, that gives an impression to the court that the other part can be left unperformed, that in that situation, courts normally, they try to pass an equitable relief that would befit the interest and the right of the plaintiff. So similarly, we have this idea also under the specific relief act, that how to get a right ascertained before the court. When we assert a right, we have to get it declared as against somebody. We have this option. We can get the right declared, and we can also get what we call as the right in terms of when we want somebody that he should not interfere into the right of into the right of the party who is aggrieved or who approaches the court, though we can get him restrained. We can get him restrained perpetually or permanently so that he does not interfere by any method or by any move. Likewise, the preventive relief is there's a scope of passing of the preventive relief also that can also be done. That can also be done while having recourse to the what we call as this the provisions of the Specific Relief Act. So, by sum and substance, I have the occasion to say that Specific Relief Act is very vital insofar as the recovery of the possession of the movable and the immovable properties is concerned, and the performance of the contracts, be determinable or not, or indeterminate in nature. And when we have to get our rights ascertained, this plays a very key. So, any questions in this regard are welcome.